Court has great interest in the questions surrounding the grand jury and that the volunteer part of it. Talk more about that piece, sir.
I'm not really going to have anything more to say other than that. I told the court clearly this court was as prepared for this argument and that issue as any appellate court that I've seen in 35 years of practice. And certainly today's my first argument as a special prosecutor.
Going into the court, you said this was about the criminalization of securities fraud. Can you talk a little bit more about that?
Not really. Not really. I think what mattered today was what the court talked to the lawyers about. The beauty of oral argument is that it's the only time really in the process where you get to directly address the people who ultimately get to decide the case. And look, this is a case that matters to both sides. This court was as prepared and interested and as engaged as any appellate court that I've ever seen.
They also seem very interested in this idea of not having to register because of the federal registration. Can you talk about that?
Total red herring. Our position is set out in the briefs, it's dealt with an argument, it's really a non-issue.
Talk about the grand jury questions. There seem to be a lot of questions from both sides, to both sides about the grand jury.
Well, I mean, at the end of the day, we don't think that it's cognizable, which is a fancy legal term for wrong place, wrong time, number one. Number two, Judge Older, a dedicated career jurist, and these 12 folks who took an oath not to indict from envy, malice, or hatred did what they were supposed to do, and that there was nothing at all untoward about the impoundment or composition of the grand jury. It's the new norm, and that's not me, that's Gail Lyga, who is a veteran grand jury prosecutor who's a whole lot smarter than me.
It wasn't just this grand jury chosen that way, it's the way that all the grand juries are chosen that way. So it affects not only this case, but thousands of cases.
Which is exactly what Chief Justice
Chief
Wright
Justice was
said.
concerned about that.
And yes, she was absolutely on.
And
God-
because you asked for volunteers, it doesn't make it less random. The randomness was in the way that they were brought to the courthouse to begin with, and the way that they were assembled in the courtroom. And as Brian pointed out, the judge can take the first 12, middle 12, or last 12, or ask who doesn't want to be on the grand jury out of the random pool that is left. And the fact that some people have excluded themselves because they don't want to serve doesn't make it less random. Randomness was there to begin with.
This was as random a grand jury as I've seen in 35 years of practice. And again, the facts are stubborn things, and the facts are that Judge Olmer went to great lengths to ensure that this grand jury was the ultimate cross-section of commonality, both in terms of age, sex, and more importantly, geography. That's all the statute requires. It requires no more, no less.
And this was not a special, so they did not know the cases that might come before them at the
They had
time.
no idea.
No, this grand jury had no more idea that they were going to hear the Paxton cases that who's going to win the Preakness.
And the judge didn't know when the case was going to be presented. He didn't even know if it'd be presented in his grand jury. We didn't make that determination until after that grand. He didn't get there on a Thursday, so he had to do it on a Tuesday. That's the only reason this case even got presented to him. It's total smokescreen.
Mr. Paxton has called this a political witch hunt, but we haven't heard that from his attorneys. Can you speak
That's
to?
because attorneys are too responsible to comment on such things like that, especially when there's a court order addressing that. But that's to be discussed another day.
Do you think that his video last night violated anything
I
about the
think
court order?
nothing about that video.
At this point, what's a reasonable timeline for trial?
That's a great question. The Third Court of Appeals took 90 days to the day to decide Perry. The Court of Criminal Appeals took 90 days to the day. I know that because I have too much time on my hands. And so we're looking at between 60 and 90 days. And whenever this court decides to issue its decision, and it could be any day of the week, we're confident and cautiously optimistic that they believe that Judge George Gallagher, one of the best in the biz, got it right. That's all.
Brian, just make sure you're going to answer. You're Mr.
Sure. Brian,
I want my attorneys to kind of brief you on what happened. I just want to say I think it went very well. I'm confident in the legal process and the people of Texas. I think my attorneys were able to show some of the flaws in the case. I just want you to know these are false charges and we will prevail. Meanwhile, I'm going to continue my job as Attorney General, the job that the people of Texas elected me to do. Thank you all very much, and now I'd like my attorneys to take a few statements.
thanks, Gary.
So, let me just start out by saying, guys, I think I know what Muhammad Ali feel like when he got the heavyweight crown. It was a good day for the home team, and it was a good day for Ken Paxton. So let me tell you a little bit about what happened today. But before I do that, let me just say it has been an honor, I know I speak for Philippines, and a privilege to represent a very good man that is Ken Paxton. So the judges asked good questions. We believe that we gave good answers, answers which we believe will end all or part of the prosecution against Ken Paxton. Now, I want to stress that Ken Paxton is entitled to his day in court. Many, but not all of you in the press, want to seem to try this case without all of the facts, and well in advance of trial. It is important that we wait to pass judgment. We know this because a number of things of what we learned today during the argument. We learned a number of things, including that the law says that Mr. Paxton did not have to register with the state of Texas because the investment advisor he allegedly represented was already registered with the feds. You have to ask yourself, isn't being registered with the feds good enough? You learned that the Texas State Securities Board continues to rely on an outdated, federally preempted definition of who is a representative and investment advisor, which mandates that the state's prosecution be dismissed. You learned that the district judge who impaneled the grand jury, which returned an indictment against Mr. Paxton, was impaneled by asking for individuals to volunteer, something the Texas legislature has been working to eliminate since 1979, in which it thought it had eliminated this last legislative session. I can tell you about the things that we have filed. I can tell you about the things in open court from today. I'm restricted from telling you about things yet to come, but know that they are many, and we are confident that Mr. Paxton will be vindicated once he has his day in court. So I encourage you not to try him before you've heard all the facts. And I encourage you not just to write stories that seem dead set on impugning Mr. Paxton.
Bill, I
Take
want to ask
questions.
you about, first, the Chief Justice seemed very concerned about if in this case, the Paxton case, and questions about the grand jury and volunteering, and if they were found to have no authority in this case, the impact that would have to other cases heard by this panel and even across the state to other cases where judges had impaneled the grand jury through this similar type of questioning, volunteer.
Sure. Justice Wright's question was a great question because the fact is that any grand jury that was impaneled using a volunteer system in Texas is illegal. And we know that it's wrong to do it because the legislature, starting in 1979, started to get rid of non-random grand juries. And as of this last legislative session, it mandated that we can no longer have non-random grand juries. And what happened in this case is that, in fact, it was a non-random grand jury.
But Justice Francis seemed to take point with that, to that with you, and suggesting this is effectively of time, considering the people who are sitting there.
You know, Justice Francis' question is a great question from a time standpoint, from a practical efficiency standpoint, but that's not what the legislature has mandated. The legislature has basically said there's kind of like a cookie cutter approach that judges need to take, and they need to go through grand juror by grand juror whether or not they're qualified to serve. And in this case, it simply did not happen.
Bill, do you agree with the claims made in General Paxton's video last night about this being politically motivated, about him being targeted for his faith and potentially by political opponents from the Attorney General's race?
So, like I can talk about, what I told you at the beginning, I can talk about what we filed in court, and I can talk about what we said in court, okay? There are things yet to come, and you're going to have to wait.
Did you know about that video last night?
I saw
Did
it
you learn
late
about
last night.
like
yes.
everybody else?
I saw it for the first time late last night.
Bill, you said in your argument you gave the court the narrowest way to decide the case,
That's
focusing
right.
on the investment advisor issue. But aren't there still 2 first-degree felonies left after that?
Well, but if it grants habeas writ 3, then it will dismiss those securities fraud counts.
If they do the grand jury, but there's still,
That's right.
if they just take your position that you decide this in the narrowest way, there's still 2 other first-degree charges left.
If they don't dismiss based on the proper grand jury impanelment, you're right.
So, do you guys, are you looking forward to a trial on those? You know, if they don't decide the grand jury issue, if they leave that out?
Well, we're obviously hopeful that the court's going to grant habeas writ 3 and strike down the grand jury indictments. But you know what? If we have to try the case based on securities fraud, we're looking forward to that. So,
Where do you go from here? Like, what happens after this? Where do you go from here?
well, you know, the court's obviously going to give us a ruling. We hope it will give us a ruling sooner rather than later. We expect it will because it's already expedited this proceeding. And the truth is that I expect whoever loses is going to take this up to the Court of Criminal Appeals. case, just like Rick Perry did.
Any comparisons between the Perry case and this one in the general sense?
You know,
From your standpoint?
Not really. I mean, the Perry case absolutely helped us, but we're not relying upon the Perry case. The Perry case basically said you can look to extrinsic evidence and use that kind of evidence in a habeas proceeding like we have here today. It also said that where there's no fact issues to try, why not go ahead and take care of it pre-trial without having to burden taxpayers with the cost of the prosecution, without burdening a judge and a jury having to sit through the trial. So Perry was a very helpful case to us, but it's not something that we rely on.
Any general sense about whether they might rule on this within 90 days? There have been some past precedent as far as scheduling and stuff.
You know, I certainly don't want to put a timetable on this court, but I would anticipate that they're going to give us a pretty quick decision.
Are you gonna, if you don't get what you feel is fair, the general
You know, I think we've got to look at the decision that the Court of Appeals comes down with, and if for some reason it's adverse to Mr. Paxton, you know, we'll evaluate it, but I think, as I mentioned earlier, it's likely that whoever loses here is going to take it up to the Court of Criminal Appeals.
Name and spell it just in case.
Bill